Good morning, students. In this lecture, we will discuss about the doctrine of election, which is imbibed in section 35 of Transfer of Property Act 1882. If you will go by the section, then you will find it says election when necessary. Where a person professes to transfer property which he has no right to transfer, and as a part of same transaction confers any benefit on the owner of the property, such owner must either elect either to confirm such transfer or to dissent from it. And in the later case, he shall relinquish the benefit so conferred, and the benefit so relinquished shall revert to the transferor or his representative as it has not been disposed of. Now, if you will find, then this doctrine of election, it is an equitable doctrine. This is purely an equitable doctrine, and it is a doctrine of highest equity. Likewise, you can say that this doctrine, it applies to all the persons irrespective of personal laws, and even this is, you will find that this is common principle, and it is common to all the laws. As you all know, that equitable principles are equal and common to all laws. So in the same way, you will find that it is not only a principle of Indian law or English law, and that is why Privy Council has also applied the doctrine of this doctrine of election even before the passing of the in Transfer of Property Act in 1882, because it is this on the basis of equity and justice they apply this principle in Indian conditions also. Further, you will also find that on the this point of doctrine of election, you will find that it is different from the English principle of election, in the sense that English doctrine of election or English principle of doctrine of election, it is based on the compensation, while in Indian doctrine it is based on forfeiture. In the sense that under English law, you will find the refractory donee, that means who has refracted from the election, he may retain the benefit and he may refrain the burden, but when he is refraining the burden, then he will has the liability to compensate the disappointed donee. But under Indian law, that the situation is not so, because under Indian law, refractory donee cannot do so, and he will have to forfeit the benefit and liability both. That means if he is just going for the acceptance of benefit, then he will accept the liability of or the burden also. But if he is not accepting the liability, then he has no right to make an election regarding the acceptance of benefit also. And therefore, you will find that we will discuss he will forfeit the benefit and liability to compensate. It falls on the transferor and not on the refractory donee. So in this sense, you will find that under Indian law and English law, this doctrine of election is different. Regarding the compensation, it is different. Further, you will find that this principle, it is wholly a principle of equity, and you will find that if you will go for the analysis of this section, then you will find that the doctrine of election, it is given in section 35 as we are discussing. And whenever any person, suppose if A says, or if A transfers a property or transfers or proposes to transfer any property in the sense, because you will find that section 1 to we have discussed also that this Transfer of Property Act, it is applicable because this chapter 2nd, it is applicable in most of the sections of this chapter 2nd. They apply to movable as well as immovable property both. And you will also find that this section 37 till section 37, they applies to movable properties also and immovable property also. So therefore, in doctrine of election, whenever a person A proposes to transfer or transfers any property, whether that property is movable property or that property is immovable property or It is a mixture of both. Mixture of both in the sense that means through the same instrument he is professing to transfer or proposing to transfer and transferring movable property also and immovable property also. And that is his own property to any other person. And firstly, you will find that A is transferring his own property to a person, and at the same time, in the same transaction, by the same deed, he transfers or proposes to transfer any property, that means maybe movable or immovable, of that other person. That other person means if A is transferring B, then he is through the same transaction, through the same deed, he is transferring the property of B also to C. Then in such a case you will find that B is under an obligation either to accept the transaction or to reject the transaction. Transaction in the sense both the transactions. That means he is getting the property of A. If he accepts the property of A, then he will have to transfer the property or his property also to C, which through the same deed A is professing to transfer or A is transferring. And if he denies his transferring of his property to C, then he will have to deny the benefit, that means the property which he is receiving from A also. So that is what we are saying, that whenever a person accepts a benefit, then he will have to accept the burden also. That is what the doctrine of election is imbibing. That means if you are driving a benefit, then you will have to get the liability also or the burden also. And it is your option either to choose both or not to choose both. So therefore in this sense you will find that English law and Indian law, because an Indian law says that you will have to choose both, while English law says that you can choose one thing also. That means either benefit or and if you are choosing the benefit, then you will have to compensate for the liability. But Indian law says you will not have to compensate for the liability, either you will have to choose both or you will have to reject both. Now on the point of liability, again further you will find that it is the transferor who will have to, that means A will have to just give something to C, not the B. Therefore that is what you will find further. Subject the nevertheless, next paragraph of section 35, subject nevertheless where the transfer is gratuitous and the transferor has before the election died or otherwise become incapable of making a fresh transfer. Now suppose transfer is gratuitous and transferor he has died before the election. So then he becomes incapable of making a fresh transfer. Then in all such cases where the transfer is for consideration to the charge of making good to the disappointed transferee the amount or value of property attempted to be transferred to him. That is what you will go in the illustration, then you can have a clear cut idea of this. That means it is saying the farm of Sultanpur is the property of C. That means it is the farm of Sultanpur is the property of C, and this property is worth rupees 800. And A, by the instrument, professes to transfer it to B. That means A is professing to transfer the property of C, which is of value of 800, to B. And through this same transaction, he is giving rupees 1000 to C because he is transferring his property to B. And C elects to retain the farm. That means he is rejecting the election. He is neither accepting the benefit and not that is what he is not accepting the burden. That means he refuses to transfer his property to B, or did not allow A to transfer his property to B. Then in such a case he will have to forfeit the sum of 1000 also, because he is not transferring his property to B. So therefore in the same case, if A dies before election, that means before the acceptance by C or before the rejection by C, A dies. Then in such a case his representatives must give 800 rupees to B out of 1000. That is what the second line of this section 35 or second paragraph says. That if he is died or if he is incapable of making fresh transfer, then the amount up to the value of the property which is to be transferred, that amount should be given by the representatives to the person or to the donee. Now, this they are saying for the illustration only. The rule in the first paragraph of this section applies where the transferor does or does not believe that he professes to transfer to be his own. That means it is immaterial that whether A knows that he is transferring his property or A knows that he is not transferring, that the property does not belong to him. It is immaterial whether that property belongs to A or that property belongs to C, which is subject of transfer. So, therefore, you will find further they are saying that a person taking no benefit directly under a transaction but deriving a benefit indirectly need not elect. So, we will discuss all this further. They are also saying that a person who is in his one capacity takes a benefit under the transaction may in and dissent therefrom. So, therefore, you will find that this doctrine of election, it is clearly saying that you can This is clearly saying that one who accepts a benefit under an instrument will have to accept the burden also which has been created in the instrument. This is what the equitable doctrine of election is stating. Because election, what do you mean by election? Election means that you have a right to choose. Choose between the two rights. When you will have the right to choose between two rights where there is clear intention, express intention, it may be express intention which is clear, or it may be implied intention which is clear, and which says that both are not to be enjoined. That is what you can say the election. That means either you will have to choose this or you will have to choose this. So this is the very foundation of the doctrine of election. And this is the characteristic you will find in this section. So you can say that this choice is voluntary. It is not thrustable or it is not burdensome. It is voluntary. So, and it is voluntary and it is also founded on the equitable doctrine that one who accepts the benefit under the instrument will have to accept the burden also under the instrument. So that is what you will find in the first paragraph of this illustration given under section 35. And you will also find that this doctrine of election, though it was first applied to wills in England, and later it was extended to other conveyances also and settlements also. And this principle is in clear sense, you can say it is stated in the case of Cooper versus Cooper. And further you can also find that the circumstances in which a person may be put to his election, they are that where another person transfers his property to someone else. That means it is the property of B, but A is transferring the property of B to C. Or by the same instrument, and as a part of same instrument, the transferor confers some benefit out of the property on such person. So transferor is giving some, you can say, same instrument, he is conferring some benefit out of his own property. So when these circumstances exist, then only you will find the person whose property is transferred has got to choose whether he would have to take the benefit conferred upon him or not. It is his election that if the benefit which is given to him, if he is accepting that benefit, then he will have to accept the burden of transferring his property to some other person. Further, you will also find that this principle becomes inapplicable or it is not open to the court to compel a person, because this is the equitable doctrine and it cannot be thrusted upon. So even court cannot thrust upon one person to choose one remedy in law out of the two options, or instead of another one, court can compel the person to choose other option. No, that cannot be allowed. Further, the benefit and the burden for the application of this section, they will have to arise from the same transaction. If the transactions are not same, then doctrine of election will not apply. And this you can find in Muhammad Afzal's case, that is Muhammad Afzal versus Ghulam Qasim. It is the case of 1933. And further you will also find that it is the owner's duty to elect. Owner's duty, that means if A is transferring the property of B to C and giving some amount to B, then who is the owner? B is the owner. So it is the option of B to elect. If B accepts or B rejects, that is his option to election. Further, they are also giving exceptions to this last preceding 4 rules in the same section, where you will find where a particular benefit is expressed to be conferred on the owner of the property which the transferor professes to transfer, and benefit is expressed to be in lieu of that property. If such owner claims the property, he will relinquish the particular benefit, but he is not bound to relinquish any other benefit conferred upon him by the same transaction. Acceptance of the benefit by the person on whom it is conferred constitutes an election by him to confirm the transfer, if he is aware of his duty to elect and of those circumstances which would influence the judgment of reasonable man in making an election, or if he waives inquiry into the circumstances. Such knowledge or waiver shall, in absence of evidence to contrary, be presumed if person on whom the benefit has been conferred has enjoyed it for 2 years without doing any act to express dissent. Such knowledge or waiver may be inferred from any act of his which renders it impossible to place the person interested in the property professed to be transferred in the same condition as if such act had not been done. So that is the illustration they have also given for these lines. That if A transfers to B an estate to which C is entitled, and C is entitled to the estate, and through this same transaction he is transferring a coal mine to C. Now C takes the possession of the coal mine and talks nothing about the estate which belongs to him, which he will have to which A has transferred to B. So in this case you will find C takes the possession, when C takes the possession of coal mine, it is presumed that C has transferred the estate to B. That is what you will find in first paragraph, that a particular benefit is expressed to be conferred on the owner of property which the transfer professes to transfer, and benefit is expressed to be lieu in of that property if such owner claims the property or relinquish the particular benefit, then he is not bound to relinquish any other benefit. Further, this will continue up to 1 year. That means if he does not within 1 year after the date of transfer, if he does not within a period of 1 year signifies his intention to confirm the transfer or to dissent from the transfer, then the transferor or the representatives of transferor, after the expiration of 1 year, they require him to make the election, and if he does not comply with this such requisition within a reasonable time, then it shall be deemed that he has elected to transfer. That means after 1 year the transferor or the representatives of transferor will again give reasonable time to either relinquish the transfer or to accept the transfer or to reject the transfer. And within reasonable time, if he does nothing, that means if he has not relinquished, then it is assumed or it is presumed that he has accepted the transfer. And if in case any disability arises, then the election shall be postponed till the expiration of that disability or till the cessation of that disability. So, Section 35 will apply in all the cases where transfer or proposal to transfer is under any misconception. But it is not necessary that A is having the misconception that the property belongs to him or to B, which he is transferring to C. Whether he knows it, whether he is clear cut about that, but the thing necessary is that he will transfer the property to C. That is necessary. Secondly, the occasion of election, it arises where the benefit is directly conferred on the owner of the property. If benefit is not directly conferred on the owner of the property, then the doctrine will not apply. Likewise, you will also find that a person holds two capacity. If a person is holding two capacity, that means one is individual capacity and other is maybe vicarious liability or maybe some other capacity, then he may accept the benefit in one case and dissent from the other. That is also, it may be. Likewise, that the estate of Sultanpur, which they have given, is settled upon A for life. It has been settled upon A for life, and after his death upon B. So A leaves the estate of Sultanpur to, now A is leaving the estate of Sultanpur to D, and rupees 2000 to B. So in such a case, this to C, and A is leaving that Sultanpur to D, and rupees 2000 to B, and rupees 1000 to C, and C is B's only child. Now, so, but B dies intestate after the testator without having been made an election. Then C takes out the administration to B, and as an administrator, he elects to keep the estate of Sultanpur in opposition to the will. By virtue of will, he is keeping the estate. Now, he will have to and relinquish the legacy of rupees 2000. Now, C can do this, and then also he can claim the legacy of 1000 which is given under will. It is because he is acting in different capacities. So, the mode of election the mode of election may be direct or indirect, both. And further you will also find that if one keeps the property for 2 years from the day it is conveyed to him, then says nothing. He is accepting the property and he is saying nothing, and that too after this 2 years period has passed, then you will find the law says that everybody is to presume that he has accepted the election or he has accepted the transfer or the deed. He cannot retract from it. So this is about the doctrine of election, and further if you have any queries, then you can ask in the group and I will answer them. Thank you.